Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. We have a slightly unusual program for you today, and we're going to interview the attorney who is the author of the new legal thriller, Unreasonable Doubts. And it's a novel you would enjoy reading or giving as a gift to someone. And I'm interviewing the author, Raina Marder Genton, who's here with us today, about her new book and first novel, Unreasonable Doubts. Raina, welcome to Law You Should Know.
Thank you so much for having me.
And what prompted you to write Unreasonable Doubts?
Well, I had worked for many years in a public defender's office, almost 18 years, and I left the practice there about 4 years ago, and I was trying to look for a productive way to spend my time. And I always felt that there were stories to be told, from that job, and the novel kind of grew out of to tell some of those stories.
And how closely does the novel intertwine with your real-life experiences?
Well, the office that's depicted in the novel is based on the office in which I worked, or is inspired by it, I should say. So in that way, it does track. I mean, I think I tried to give a very realistic view of what it is to represent a defendant on appeal in the New York State courts. So in that way, it does track my life. On the other hand, it's also a romance, and the romantic aspects, I would have to say, do not really track my life. So.
Well, that's where the fiction part comes in.
Correct.
So can someone learn about the law reading this book?
They will certainly learn about how an appeal is handled, how it's researched and argued. Some of the interactions are with the defendant are realistic. Some, as you say, are more fictional.
Why don't we just say embellished? Embellished,
okay. And certainly you would learn. I mean, you would learn about this particular case, which was inspired by a case that I handled on appeal a number of years ago. So you would learn something about DNA evidence, and you'd learn something about what can go wrong with DNA evidence. So in that sense, you would learn a particular, very small subsection of the criminal law. And
also strange twists in the law and in real life, and possible defenses along the way.
Correct. Right. Strange procedural things that can happen. Strange interactions you could have, I guess. Although, as I say, some of the stranger parts, are purely fictional.
But can be entertaining and informative.
I hope so.
The real concept of reasonable doubt in criminal law, what is that about?
So that's the standard of proof that it takes to convict a defendant at trial of a crime. So it's a very elusive and slippery standard. It basically says that you need to have proof that's beyond a reasonable doubt. So what does that mean? What is a reasonable doubt? And that's a question that is hard to define. In New York law, it is defined as a reason that exists based on the nature and quality of the evidence presented. So it's not something that you make up in your head. It's not something that you come to because you like the way the defendant looks or you don't like the way the defendant looks. It's supposed to be based on the evidence presented at trial. The problem with it is it's a difficult standard. It's a difficult thing to define. I worked for a year as a law clerk to Judge Leonard Sand, who was, as you know, the king of jury instructions. He wrote the federal jury instruction Bible, Sand on Jury Instructions, and we used to sit at trial, and the jurors would often come back with the question, what do you mean by reasonable doubt? And we would look at the judge and he would say, I'm just going to read it again, because there's no, he would just read the same instruction over again because that was the law, and there was no trying to explain it in some further way that would make more sense to the jurors. That's what it is. So it's a difficult standard to define.
But in a real world sense, if there is a reasonable doubt in someone's mind, even if the person looks like they're guilty, acts like they're guilty, there's some evidence to support their conviction. But if there's a reasonable doubt in the mind of a juror, I guess the concept is, many innocent people, many guilty people should go free if that person could be innocent, and if the prosecutor hasn't met their proof.
Well, that's true, and it only, it's a jury of your peers, and it's a jury of 12 people, so it only takes one person to have a reasonable doubt to acquit the defendant. But it's difficult, and it's often, I think, when it comes down to sort of an 11-to-1 situation, the one juror caves. So it's hard to know. We're never in the jury room. You never know what's really going on there, but it is a difficult standard to apply.
Unless we're in a 12 Angry Men or Women scenario.
That's another story altogether.
And is it very important to a defense counsel at trial to raise that, especially if they have nothing else that's going to work for them?
It's certainly, if they have nothing else, they have to raise that. And it's always raised. By pleading, by going to trial, you are declaring your innocence, and you are basically saying, this cannot be proven beyond a reasonable doubt. The evidence is not sufficient to convict me. So by going to trial, that is basically what you're doing. On appeal, we do everything in our power to avoid raising that the conviction was not proven beyond a reasonable doubt, because it's almost always a losing issue. That kind of issue, it doesn't work because the appellate court gives great deference to the finding of the trial court and the trial jury, because the jury is the one that saw the witnesses on the stand and can assess their credibility. And, the appellate court reading a record is never in as good a position as the jurors were to tell how somebody came off. So it's almost, I don't want to say always, but it's almost always a losing issue, and you almost always try to find something other than that to raise on appeal. So if the jury is like the referee, and if they already decided, and if they ignored the reasonable doubt issue as raised by the defense counsel, an appellate court is unlikely to second guess them. They're unlikely. It certainly happens. There's certainly cases where the evidence clearly on the record is insufficient, and then it will be reversed. But as an appellate attorney, you're almost always looking for some, especially in a sort of egregious crime, you're almost always trying to look for some issue that does not rely upon the facts of the case. You're looking for something that has to do with the evidence that went in, something that has to do with the search and seizure, or confession, or a jury problem. Somebody, shouldn't have been on the jury. Somebody, whatever. Anything that does not require you to recount in gruesome detail the facts of the case and then say, guess what, it wasn't proven beyond a reasonable doubt, because that's going to be a losing issue. And
you're trying to focus on some kind of mistake in the legal issue, or the interpretation of the law, or the charge that the judge gave the jury. Some mistake the judge made rather than the jury.
It doesn't have to be the judge. It could often be counsel. Defense counsel can make mistakes. The prosecutor can make mistakes. It's sometimes the judge. It's not usually the jury, in the sense of you're not looking to see, is this the jury's fault? Did something go wrong here? But there are plenty of jury issues. There are issues revolving around whether the prosecutor knocked off a certain racial group from the jury. Let's say the defendant is black and the prosecutor knocked off all the black potential jurors, and you can't do that. So, there's all sorts of due process and equal protection issues that come up in a trial that don't have to do with the actual, did he stab the other guy? And
there might be other issues about what the prosecutor did or did not do at trial or in pre-trial stages.
Correct. All sorts of issues. Many times there are things that the prosecutor has done in summation that are very fruitful on appeal, because there's a lot of things that you can't say as a prosecutor on summation. You can't point out to the jury, for example, that the defendant has sat through the trial and then testified and tailored his testimony to those of the other witnesses. A defendant has an absolute right to be present at every stage of his trial, so the prosecutor is not allowed to insinuate to the jury that it was wrong that he sat there while the other people testified. There's all sorts of things that the prosecutor can't do.
So bad acts or mistakes or improper things the prosecutor may have done.
Correct.
Intentionally or not?
Intentionally or not. I mean, in my novel, there's a problem with something that the prosecutor allowed into evidence, and whether it was intentional or not. And in the real case that I had, I don't know whether it was intentional or not, but it was egregious enough that it required a retrial.
And on the flip side, on appeal, it's usually sometimes a different attorney handling the appeal. And you're also, one issue the defendant can raise is the ineffectiveness of their trial counsel. And what is that about? Correct.
So what that's about is also a broad and elusive standard, but a defendant is entitled to effective assistance of counsel, and what that means in New York is that they're entitled to meaningful representation. Again, another set of words that could mean one thing, could mean another thing, but there are basics. You're entitled to an attorney who is prepared on your case. You're entitled to an attorney that shows up. You're entitled to an attorney that communicates with you and makes proper objections, seeks curative instructions, knows the law that pertains to your case. You're entitled to all those things.
And is it fair to say who vigorously defends you, who pursues every angle of investigation and calls appropriate witnesses and expert witnesses?
Those are all good, and yes, those should all be taking place. Now, there are infamous cases where defense attorneys have snoozed through portions of the trial, and the appellate division has still said that they were effective.
Or judges.
or judges, right? But the judge can get away with it. Defense counsel, you kind of hope wouldn't. But so there's all sorts of things that your defense counsel, should be doing for you, and that actually comes up in my novel, too, because not only does the prosecutor allow certain evidence in that shouldn't have been in, but the defense counsel misses it. The defense counsel has those documents long before trial and should have moved to have them redacted so that they wouldn't admit evidence that shouldn't have come in, and fails to do so.
Okay, we're going to have to take a short break now. When we return, we'll continue our discussion of your novel, Unreasonable Doubts, and some other details and descriptions of the character and the plot, along with some other concepts in criminal law that are important and a reader can learn about in the novel. We're talking to Raina Marder Genton, and she's the author of Unreasonable Doubts, a novel that's now out in bookstores and on the web. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College, and also over the internet over nccradio.org. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, helping both the public and lawyers since 1899. They are the largest suburban bar association in the country. The Nassau County Bar Association offers clinics where you can meet privately with an attorney to prevent or solve legal problems involving Hurricane Sandy, foreclosure, wills, or elder law. Speakers on almost any legal topic are also available to schools or community groups. They can also help lawyers advance their legal careers and offer a place to network. Learn more about the Nassau County Bar Association by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Welcome back. We're talking about the new novel, Unreasonable Doubts. And you were telling us some, issues about the inadequacy of defense counsel. And this can be true whether it's a high-priced private attorney or a public defender. This issue can be raised.
Of course.
And it's a very common issue that's raised.
It's very commonly raised. It's not that often a prevailing issue, but it is raised a lot.
Okay, and what about? I mean, I'm sure you get people in your career, in life, and in the book. They look at you and say, "How can defend those people?" Is it important, for you to believe the veracity of your clients in the book and in real life? Right.
So in real life, I don't. Well, let me speak as an appellate attorney, because I practiced as a trial attorney, but only in juvenile rights, so it's a little easier sometimes to believe the kids than to believe the adults. But I would say as an appellate attorney, it's actually not important at all in a certain sense whether you believe your clients or don't believe your clients. For the most part, every client you have will tell you that they're innocent, and why shouldn't they? I mean, I would say that if I were a defendant too. So certainly they want you on their side. They're going to tell you what they think you want to hear. But on the flip side of that, it really doesn't matter what they tell you on a certain level, because you are dealing with a closed record. So as an appellate attorney, I am only able to use what is in the record before me. So it's the trial testimony, the evidence that has come in, documents, whatever it is that came in at trial. So whether I believe the client or I don't believe the client really has no relevance to the job that I'm doing.
And their innocence or not has no relevance. It's whether the prosecutor has proven their case beyond a reasonable doubt and whether the client received a fair trial.
That's correct. And the way it comes up, if I may, for a minute in the book, and actually did come up in real life also, is that you can certainly go through your career practicing that way and not really trying to empathize with the client and not trying to get past. And in some ways you have to. You can't get past the closed record. It is what it is. So there's no big point in writing long letters to your client or going to visit your client, all those things, because they're going to tell you things that you can't use, and it doesn't help. On the other hand, I think that the best defense attorneys, do have empathy for their clients and do understand that these are real people that sometimes made terrible decisions, and you can't really understand what they did sometimes, but you do have to try to remember that they're human beings and that they had lives before this, and things that mattered to them before they were incarcerated. And it's definitely an easier way to practice day by day if you can dredge up that feeling for people. And certainly in the book, the main character has lost that ability. Not lost it, but she's faltering on having that ability. And I don't think I ever lost that ability, but after many, many years, it does begin to wear on you a bit.
Well, you had reasonable doubts about that ability.
I did. I had reasonable doubts, and she has reasonable doubts about that ability too. Some of her doubts turn out to be unreasonable, but she does have some reasonable ones too.
Do you sometimes get ideas from the clients when you're working on the appeal, and on what some angles might be? Maybe they are aware of some issues that the trial counsel may have missed. Was something unfair by the prosecutor, or maybe they've done a little jailhouse research themselves?
I have to say very rarely. Occasionally a client would come up with a case citation that I could add to things that I already had. As I say, it's once again, it's that question. I mean, are they going to know about an issue that I'm not going to see? I guess if, it's possible if you are starting out and you're an inexperienced attorney that a client could mention something to you and you could say, oh wow, that's kind of interesting, I better research that. But most of the time, you're doing your job and you're spotting the issues just like you would on a law school exam, right? It's not, and also, the issues tend in some ways to repeat themselves. There are certainly novel issues that come up, and that's very exciting when you find one, but often things do repeat themselves.
And tell us about some of the characters in the book.
Okay, great. There are three main characters in the book. There's the protagonist, Leona Cohen, who is a young public defender. She's about to hit her 30th birthday, And she, as I say, has been working for a number of years in this public defender's office, and she's beginning to kind of lose sight of the mission and feel like it's slipping away from her. She's not sure that this is the place to put her talents. And then she is dating a guy whose name is Jacob, who's a more standard kind of corporate attorney. He works in a big law firm. He wants to make partner. He's working his butt off. He has very little time for her in some ways. On the other hand, he's a good guy, and he's kind of carved out this space for her in his life, and he's ready to move on to marriage. But her doubts about herself kind of spill over to him. And in the midst of all this self-doubt and not knowing what she's up to, she gets assigned to represent a client named Danny Shea, who has been convicted of a sexual assault. And she starts to work on his case, and she begins to think that he might be innocent. So those are kind of the three main characters, and then there are some subplots.
Okay, and tell us about how the book starts out, and then what the reader might read about in the very beginning.
Okay, so in the very beginning...
As much as you want to reveal. Yeah,
sure. No, in the very beginning, we do see Liana in her office interacting with her colleagues and her supervisors, and she's really having a very, very hard time. She goes to an office meeting, and all the attorneys are talking about how they're doing God's work, and they come off a little bit self-righteous about what defense attorneys do in defending the underdog, and she just can't really deal with it. So in the beginning, we kind of meet her and see the quandary she's in, and then we start to kind of follow her through when she gets assigned the case and how she researches it and why she begins to have some thoughts about personal and professional thoughts about the defendant. So that's kind of how it runs, and it kind of goes through, you follow through his appeal and what happens to him afterwards and what happens to all of them afterwards.
And obviously there are twists and turns.
There are some twists and turns.
And what attracted you to do appeals for criminal defendants?
Well, I started out, as I said, at Legal Aid and Juvenile Rights, and I was a law guardian, so I was representing children in both abuse and neglect proceedings and in juvenile delinquency proceedings. And after a couple of years of doing trials, I did a 1-year rotation in the appeals bureau, and I found that I really loved it. I loved the reading, I loved the writing, I loved the research. I loved getting it up in front of the appellate division. So when I left that job, I ended up switching to adult appeals. That's a little more, to me, a little more fruitful. There's many, many more issues because the juvenile trials are not jury trials; they're bench trials. So you lose, 90% of the issues. So I switched to doing adults, and and I was there, as I say, for almost 18 years.
And just going back to your book, is there anything else you'd like to say about the book?
The book covers a lot of ground. It's really the story of a young woman trying to figure out her personal and professional priorities. She's a secular Jewish woman who has not had any religious background, but she becomes friendly with a rabbi. He's another one of the key characters in the book. And they discuss everything from, finding your bashert, who's the person that's supposed to be for you, and Jewish principles of justice. So she kind of has a trajectory that way. She doesn't become religious, but she's interested in these issues.
But you don't have to relate to that or be aware of that in order to enjoy the book.
No, not at all. I think you have to be open to the idea that there may be faith issues out there and that they may work for some people. You certainly don't have to be Jewish. You don't have to, nothing like that. It's just more, relate to somebody that's searching. She's a little bit lost, honestly, at the beginning. So.
And who, young or old, who do you think would enjoy the book most? For themselves, or who would enjoy getting it as a gift?
I hope it spans the ages. I certainly wouldn't want to give it to anybody too young. It does get a little slightly graphic here and there. Not terribly, but a little bit. So not too young. I think older people definitely can relate to it. Liana's mother is a big character in the book, and her relationship with her mother, so that also appeals to people, I think. I think, you do have to at least be interested enough in the law to, whatever it is you flip on a TV show that's about the law and you don't turn it off because it's about the law. I mean, it's not a technical book. It's certainly, you don't have to be a lawyer to read it. I think lawyers would very much enjoy it, but you just have to find that interesting. And I think most people do.
We just have about 2 more minutes. So in 1 minute, why is this a good book for book clubs? And I know you have a discussion guide in your book.
I do. I have a discussion guide. I think it's a great book for book groups because it brings up a lot of current issues. There's kind of a consent, Me Too issue that's going on in the book. There's just tremendous amount to discuss about the characters and about the issues that are raised. And
these are very contemporary issues.
And they're contemporary issues, right.
And how did you find the process of writing a book? As a lawyer or...
I enjoyed it very much. It was a lot of hard work, much harder than I would have thought, and it required a lot more input from other people, workshopping and editing and all sorts of things that I wasn't really. I was always edited as an attorney, but not in this way. So, it certainly involved. It was like a lot more collaboration just in the thought process than I would have expected. And
it's different than writing a learned brief.
It is. I mean, you're trying to do something creative. You're trying to, in some ways, evoke emotions, and hopefully I succeeded. And
where is the book available? And very briefly, what types of feedback have you gotten about the book?
Well, first, I've so far gotten great feedback about the book. I have some really wonderful endorsements from Susan Isaacs and Linda Fairstein and Bill Landay, who wrote Defending Jacob, which is one of my favorite books. And some reviews are starting to come in, so that's good. You can purchase the book online, certainly at Amazon, Barnes & Nobles, any number of online outlets, and it will be in some bookstores. I hope, people will go out to their independent bookstores and request it, and then they can order it for you. Any bookstore can get it. I'm not Scott Turow, so it won't be out on the main table when you walk in, but if you ask for it, they can get it for you.
And also someone said people who enjoy Lisa Scottalone, who's written, other types of legal thrillers, will enjoy your book.
Correct. She's a U of P grad. She's very prolific. I hope to be nearly as prolific as she is.
And do you plan on writing other books?
I hope to. I'm working on a bunch of things. We'll see where they go.
Okay, so I would like to thank our guest, Rena Marder Gentin, and it's Gentin,
correct,
the author of Unreasonable Doubts, and it should be available online, or just ask your local bookstore to order it for you. And with the upcoming holiday season, it makes a great gift for yourself or for someone else. You've been listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College. If you missed any part of this show or you want to tell anyone about it, a free podcast is available by going to nccradio.org or searching WHPC on iTunes or Spreaker, SPREAKER.com. And please join us next week on this same time for another program on Law You Should Know.